Good day. Today we have on the Medical Law and Ethics podcast the real privilege of speaking to Alex Ruck, Keene, KC, and he is joining us from London. Alex, I'm really looking forward to this conversation. I think it's going to be absolutely fascinating, and welcome to the podcast.
Well, thank you. Thank you very much for having me. I always love comparative law discussions. So yes, I'm really looking forward to this one too.
Yes, and as I said to you in the little email exchanges before just setting up the podcast, what the idea here is to get a little bit of a background of the English and more broadly the British legal system, take us through a little bit of how your judiciary works, but then also to deal with one or two specific issues within the medical law and ethics field, and we'll get into that in some detail, but to not so much look at the technicalities of the differences between our divisions, but to look under the skin and under the surfaces. What are the common challenges which different societies face, and what are the solutions that they'd be coming up with, and hopefully learn from each other, and just interestingly sort of exchange general growth points. That I also find these conversations really interesting. Okay, Alex, if I can then introduce you, just before I do that. So the discussion points for the podcast is that we'll have a look at a background to Alex Ruck, Keene. We'll then discuss the British legal system, and we'll look at then, within the context of the British legal system, we'll discuss the Court of Protection in the UK, and we'll discuss the Court of Protection, which is a specialised court within the UK, and Alex will give us some broad brushstrokes on the Court of Protection, give us an understanding. They do some fascinating work from the medical law perspective. Following what the Court of Protection's thinking is really informative, because it's a focused court and it can deal with some, as you'll see, we'll have an example today, with some really stimulating and interesting challenges to society. So that court, I think, works well from that point of view, but I'd be very interested to get Alex's thoughts on that. And then we'll turn to a subject that Alex will I'm sure, be able to assist us on to quite a great extent, and that's assessing mental capacity, how mental capacity is assessed, the context within the general sphere of medical law. And after that, we'll turn to the role of the expert witness. And Alex and I will share some thoughts on expert witnesses, the role that they play within our two jurisdictions, and some thoughts on sort of the do's and don'ts of expert witnesses, but also how our jurisdictions tackle the proper presentation of expert evidence broadly before the courts. And then we'll finish on a discussion about advanced directives, and there are a few developments in South Africa, and I'd like to also hear Alex's thoughts on advanced directives within the UK and the England and Wales in particular within their context. So having said that, Alex, welcome.
Thank you.
As a background, Alex Ruck, Keene is an experienced barrister, writer, and educator. His practice is focused on mental capacity, mental health, and healthcare law. He also writes extensively, editing and contributing to leading textbooks, and amongst many other publications, the 39 Essex Chambers Mental Capacity Law Report, which is known as the Bible for solicitors and others working in this particular area of the law. He's also the creator of the website, Mental Capacity Law and Policy. I've had a look at the site, very interesting, rich content, providing resources and expert commentary on some of the most difficult mental capacity issues. And I must say, the issues that come up are challenging, and if I can say without embarrassing Alex, really well presented and handled on that site. Alex complements his barrister's practice with a deep interest in research and education. He's a visiting professor at King's College London, a visiting senior lecturer at the Institute of Psychiatry, Psychology and Neuroscience, King's College London, and a research affiliate at the Essex Autonomy Project, University of Essex. In addition to his academic positions, he lectures widely on the Mental Capacity Act and the Mental Health Act, and trains judges, social workers, doctors, nurses, and other professionals who have cause to work with them. So Alex, that's your field. Tell us a little bit about your work in that field and your background, how you got to these positions. Obviously, a lot of hard work and a lifetime's work has gone into this. Maybe take us a bit through your professional journey.
Oh, well, thank you. Well, thank you again for having me. I'm really glad to be here. So yeah, now I ended up here, not only by accident, but I ended up sort of here by accident. I came to the bar in England and Wales with a real interest in public law. That's what I was interested in. I was interested in policy, and I didn't really want to be a civil servant. I didn't really want to be a politician. And I thought the other way into thinking about how does law interact with kind of wider society is through public law. And then my chambers traditionally had done quite a lot of the cases under what's called our inherent jurisdiction. So before the creation of the Mental Capacity Act, the High Court had a jurisdiction it basically just made up to try and deal with the situation where people seem to lack capacity to make decisions. So we'd done quite a lot of that. And I sort of came in at the tail end of that. And then at the very beginning of our new Mental Capacity Act, I actually did the very first case under it, because the more senior person who was supposed to be doing it was too busy. So I vividly remember sitting there with 2 other practitioners and a judge, none of on day one going, what is this thing? And it was, I mean, at that point I went, well, I probably know as much as anyone else, slightly arrogantly, but I did at least have a sense of being in at the beginning of something. And what I found completely fascinating about it, and I still do 15, 16 years later, is I always train on the basis it's 1% law and 99% ethics. It's incredibly good, our acts, our legislation, at saying, well, you could find someone to lack capacity and you could say this is in their best interest, but it says absolutely nothing about should you. And it's all the shouldness I find fascinating, where that comes from in terms of, well, what are the drivers? Is it the doctor's own conscience, or is it the doctor's fear of being done by a regulator, or is it the nurse's previous experience with the patient who seemed to be a bit like that, or is it someone's implicit biases? It's all of those things, and I find those things fascinating. And over the course,
can I just to jump in on that? So, just to help for those that maybe don't have a legal background. So what I'm hearing there is that you can have this sort of the formal structure of the law in place, and it can in fact be, the structure cannot be better than just okay. It can be a very good structure, but it's how you fit the particular circumstances of that case into that structure, and how the system deals with it, right from the barrister or the advocate from the legal team, obviously through channeling through to the presiding officer, and how they apply the law. There's often the nuances of a fact-rich inquiry that makes the difference. And the other point that I just want to jump in with there is just as you were talking about having the sort of the statutory structure in England and Wales. In South Africa, we don't have that. So we approach it still on the basis that it's really a bit of a piecemeal basis. There's a body of precedent. In other words, there are cases that are decided and will guide the judges, but the judges do deal with it on a case-by-case basis. And that then gets you to that point where they're looking at the specific facts, how they're presented, and then what's right and wrong in the circumstances, in the context of the law. So the law's a bit of a framework, and then you fit the facts of the case into that framework.
I couldn't agree more. And actually, I was going to go on to say, actually, one of the reasons I've moved away from doing all of my time in court now, in fact, I probably spend at most a third of my time doing, as it were, conventional bar work. I mean, not bar as in going and serving drinks, but work as an advocate or advisor, is actually, I think it's just as important understanding how the law, whether it be a statutory framework or a common law framework, in other words, a judge-made framework, how that is actually applied by people in practice. So what does the nurse do? What does the doctor do? What does the dentist do? And I spend a lot of my time now working, for instance, with medical bodies on drawing up guidance. I also spend a lot of my time actually just doing training of frontline professionals, because, and in fact, whenever someone asks me as a junior lawyer in England, and indeed I'd say anywhere, I want to get into this area of the law, I would say it's incredibly important. In fact, I'd say it's essential that you spend at least part of your time engaging with professionals on things which aren't the case which has arisen for decision, because then you get a much better sense of understanding, well, where on the spectrum of this is completely routine clinical practice, which might need challenging, but it's completely routine clinical practice, to this is really unusual. Unless you do that training and you see people just with the things that they do on a day-to-day basis, you don't have the first idea of where it sits. And actually,
well, absolutely. And Alex, that's where this notion of the reasonable practitioner
completely,
and it becomes important. And it's very easy to sit as an armchair critic and look at sort of a notional theoretical framework without understanding the practical context within which those actions are happening. And the point related to that is, you know, the judges, both in my jurisdiction and yours, will obviously rely heavily on expert witnesses to assist in understanding the sort of the factual context. In fact, in South Africa, I don't want to speak for your jurisdiction, but in South Africa, one of the recognized areas in which experts will be able to persuade judges or to express their opinions in respect of is exactly what's acceptable in standard practice. What is the reasonable standard? And it's that presentation of expert evidence to explain the nitty-gritty of how this happens in practice and what is kind of acceptable and then what's frowned on. Then the last point I'll make on that is that, however, having said that, ultimately it's for the judge to decide on what's acceptable conduct and what isn't with the guidance of the expert.
I couldn't agree more. I suppose I agree. I would very slightly differentiate between the situation where we're looking after the event where something's gone wrong, and there we really are. So, and I think in both jurisdictions, probably framed in slightly different language, but in both jurisdictions where we're looking back after the event saying, did this medical professional step outside the bounds of reasonable practice? And that would help indicate, well, they might have then breached the duty of care. So that's that looking backwards. But I think it's, and I think the way you framed it, I completely agree with. But it's also the thing I find quite interesting is I do quite a lot of work now in intervening in, as it were, real-time decision making. So where a court is trying to decide, I mean, either our Court of Appeal or our Supreme Court, so our two appellate levels, where they're trying to decide, well, how should we think about these situations generally? Then I spend quite a lot of time now intervening on behalf of medical bodies to try and put before the court, this is the context. So just to concretize it, not to talk in the abstract, there was a case a few years ago where there was a big issue about whether or not you always needed to go to court before you withdrew artificial nutrition and hydration from someone who was in a permanent vegetative state. And there'd been an understanding that you could never withdraw that without going to court. Right. And if the Supreme Court was having to grapple with, well, is that actually the law? And so one of the things we did was I intervened on behalf of the Faculty of Intensive Care Medicine to explain, do you understand how many people die in England and Wales every day on intensive care who don't have the capacity to say yes or no to the continuation of life-sustaining treatment? Logically, that is exactly the same position to a position where someone is having clinically assisted nutrition and hydration removed. Either you need to have a judge on every single case because effectively you don't trust the doctors, or you say, actually, there's no legal obligation to have a judge on every single case, but there are going to be certain categories where you deem, where there's a disagreement or something like that. And it was that element of really being aware, and it's a different way of putting the expertise point, but I think it's also a really important point your listeners need to understand. Most judges will never have been anywhere near a hospital. They don't have the first clue of what it's actually like to be in intensive care. And unless they've got people actually able to explain to them contextually, do you understand what on ICU, what intensive care or critical care or how it's described in South Africa, what it's like? These are the sort of, this is the patient group. This is within that patient group, the number of patients who are actually going to have ability to give the sort of informed consent you would normally like. You have this real danger that judges make decisions which are very abstracted and don't actually reflect this is how clinical practice works. And I suspect you'd be able to come up with situations in South Africa as well, but we've certainly had situations where judges have decided things at a very high level of abstraction without being fully aware of actually clinical realities. And then the clinicians have gone, oh my gosh, are you really telling us we need to do X, Y, and Z? And actually, that's not what the judge was meaning at all. It's just that they, as it were, hadn't had, it's almost like the intermediary, or this is how you speak languages, the intermediary between the clinician saying this is clinical language and the judge saying this is legal language. And you've got the two somewhere in the middle saying, actually, within that framework you mentioned, Ian, this is the framework, this is how we think things should work. So that's why I spend quite a lot of, still on where I got to how I am, but that's why I spend quite a lot of time now involved in that kind of weird middle ground where I'm trying to get, as it were, the law to understand what medicine says. And then
so Alex, just to finish on that point, and we'll pick up on your journey in a moment, but
no, we've definitely finished on that. Yeah.
I just want to pick up on that, just to follow through on that. And I think the way that you've expressed it is absolutely spot on. You know, you have the difficulty or the risk of a judge dealing with a narrow set of facts and with narrow information without proper contextual understanding. So could within a context not be the best thing, but then restricted to that factual matrix.
Yeah.
The question that occurred to me is, so what's your view on the best way to blend the two, to bridge the gap?
That's a very, very good question. Well, one way, I suppose, the first point is almost that the judges need to remember and always realize that they're only dealing with the very narrow situation before them, and to resist the temptation, which some of our judges historically have had and some still do, of straying into much greater sort of sweeping statements. Because the sweeping statement might well make, or that statement might well make perfect sense on the facts of that case, but when it's swept more broadly, and you get people who, you know, they don't know how to read a judgment, which is not a criticism. A clinician goes, I don't know what I'm supposed to do with this decision, which is not quite about my area, but it seems to be. Well, how am I supposed to follow it? So you've got that, and then the other aspect is, I think there is, I mean, it's partly because that's one of the things I do. I'm not saying it's the only thing which people can do, but you do try and get, especially on those cases which go up the food chain, so they've got therefore a greater weight in terms of other courts having to follow, is you do get the medical bodies, you know, whichever the relevant medical bodies are within the country, to intervene and say, this across the piece is how we regard it. And then at least gives the chance that the judge has got, okay, so I've got someone before me arguing about the narrow facts, but at least I've got a sense that this is what the bigger picture might look like. But no, I think it's a perennial issue, and it's a particular problem where you've got judges who like, as it were, going quite big because they quite like grounding their state. And partly it's an understandable thing that you've got a judge going, I've got a very difficult situation. Well, how is the kind of, I want to frame it within a broader principle. You know, there's a kind of, that's a natural way of thinking. But if you frame that natural principle, that broader principle too widely, you can sometimes end up with really quite kind of profoundly adverse consequences, which if you ask the judge, I'm absolutely sure the judge would go, oh gosh, I really didn't mean that.
Unintended consequences.
Yeah.
In our system, we have the procedural, the ability for parties to intervene as what we call amicus curiae.
Yeah.
And we do find that, but what I would say, just my point on that, is it's also sometimes disconcerting that you'll have a judgment from one of the more senior courts. In our division would be the Constitutional Court, the Supreme Court of Appeal, without that input. And so you have law being made, which has, especially in an area where there's not much law. So if you have an area where there's not much law, and now you have a pronouncement by a senior court, the Constitutional Court, you normally do find people intervene at that in that forum. But the Supreme Court of Appeal, the amicus curiae procedure, very often I think is underutilized and to the detriment of a broader understanding for the exact reason you've sketched now.
Yeah, which is why I think it's, I mean, I do spend an awful lot of my time here now bothering medical bodies saying, you know, there's this case, I think you should intervene, which obviously comes a bit dangerously close to saying, can I do it? But I mean, I should, to the extent relevant, I always do it pro bono because it's, you know, it's a public interest thing. But I do think there is a real kind of, I think there is, yeah, as you say, it's a kind of wider public good issue sometimes.
I think that's right. All right, Alex, can we just move on to, I'd also like to discuss the British legal system.
Yes.
And let's just get a background to that. In many respects, it overlaps with the South African legal system. And in fact, when we say that it applies, well, that commonality applies across the Commonwealth of Nations to a large extent. And the Commonwealth involves over 50 countries. So there's within medical law, there is an overlap to a large extent between these countries. And that's where one can have a look at this comparative law, because the systems are similar and historically have similar roots. But I think just give me a bit of a background to the British legal system. You've talked about different levels of courts. Give us maybe a bit of a structure to the courts. And then I think what would also be interesting is to hear the structure of the legal profession, and then I'll come in from the South African side and just add my 2 cents worth. And you just take us through those 2 aspects, please, Alex.
Sure. One really important point to make is, in one way, there is no such thing as a British legal system. And my Scottish colleagues at this point would be leaping up and down and saying, how dare this man speak for Britain? Because there's the legal systems in England and Wales are actually very different to the legal system in Scotland, because the legal system in Scotland is much more of it's much more informed by Roman law and by civil law. So there's a much lesser role for the judges making law, in the same way that the common law, which really is where things come from in England and Wales, and similarly, as I know in South Africa, there's that very big role. And that's why we have this kind of commonality across the Commonwealth of Nations, where you have a very big role for the judges, the judge-made law, sitting alongside statute law. So we're divided into England and Wales, which is one unit, Scotland, a completely different unit, and then Northern Ireland, which is a different unit again. And even just down to my area of law, mental capacity law is completely different in England and Wales, Scotland and Northern Ireland, which is interesting when you're trying to do, as citizen of the UK, moving between the 3 gets quite complicated. So, but narrowing down to England and Wales, as I said, there's traditionally a very big role for, or been a big role for judge-made law. That's common law, for instance, is where the idea of the doctrine of necessity came from, and the doctrine of best interest. So in other words, what the doctor's supposed to do where their patient doesn't seem to be able to consent. Then we've got overlain onto that, and wherever the 2 are, as it were, exist, the statute always take priority over the common law. We've got statutes, lots of statutes. The one I spend most of my days with is the Mental Capacity Act. In terms of how it's then thought through, we've got different tiers of court, different levels of court, and we've got criminal courts, we've got civil courts, we've got family courts. Narrowing sort of really the sort of medical law area, the 2 sort of main courts you might be engaged with or reading judgments about or from. One is so-called the Queen's Bench Division of the High Court. So that's where the big personal injury, the big medical negligence claims traditionally have been heard. Actually, there are 3 courts, so there's that one. The second is the administrative court. So that's another part of the High Court. That's where public law challenges are brought. So in other words, challenges to the rationality of government or public body decisions. And then entirely separately, and the judges in the Court of Protection would want to make this very clear, it is not part of the High Court. It is a completely separate standalone court, was created in 2007, called the Court of Protection, which is a standalone court designed to basically have oversight over the Mental Capacity Act. And I'm sure we'll come on to talk about that a bit more in a minute. So we've got, so in a medical law zone, you might be thinking about Queen's Bench Division, personal injury, medical negligence, that kind of thing. Admin court, public law, Court of Protection. Does this person have capacity to make this decision about this decision? If they don't, what's in their best interests? In terms of the sort of lawyers, in terms of the legal structure, there's still, although it's slowly collapsing, quite a strong distinction in England and Wales between solicitors and barristers. That stereotypical distinctions being that solicitors are employed, barristers are self-employed, solicitors are generalist, barristers are specialist. Solicitors are the people who advise and act at first instance, but they don't necessarily act in relation to clients, but they don't go to courts. Barristers are the people who stand up wearing wigs and go to court. It's collapsing in the sense that most barristers don't wear wigs most of the time, apart from in the criminal courts. And many barristers now are employed, and many solicitors have rights of advocacy. So the 2 professions are slowly coming together, but there is still a distinction. I mean, I'm a barrister, I'm a self-employed barrister. I work with actually now a lot of other people in a set of chambers, but it's just me, as it were, responsible, as opposed to being a partner or an associate in a law firm.
So Alex, I can tell you that from the South African perspective, the structure is very similar. So a member of the public can't go directly to, so let's start with the solicitors in South Africa, very, very similar, but called attorneys. And then what you would call barristers, we call advocates. A member of the public can't go directly to an advocate, unless, except in very exceptional circumstances. There are some exceptions, but generally the member of the public must first go to an attorney An attorney will then instruct an advocate. And traditionally, and it still is largely the case, although I agree with you, it is slowly breaking down. But the areas of speciality of the advocate will typically go to the High Court, years back was the Supreme Court, and present the case and appear in court. And the attorney will prepare the matter. And quite a colourful way to describe it is one of my instructing attorneys once explained to me when I started practice, and he gave me one of his first instructions. And he said to me, Ian, the difference between an attorney and an advocate is the attorney sets the stage, makes sure that the sound is working properly and the lighting's on, and the advocate's got to get on stage and rock and roll. That was his description. And there's a lot to it, Alex. You learn over the years that there's actually quite a lot of wisdom to that in a way. But anyway, so that is an amusing way to remember it. So, all right, so that's the difference between the professions. And you've touched on the court of protection, and that's something that I'm really interested in talking to you about. You've already mentioned how it was formed as a result of the Mental Capacity Act and was formed in 2007. But give us an idea of how it works and its place within the legal system in England and Wales.
So yes, actually, just before getting there, I should have just said the routes of appeal from any of the courts I've just mentioned are up to our Court of Appeal and then our Supreme Court. So that's the kind of ranking, as it were. So the Supreme Court. And I think I should just
add, you'll be familiar with it, but people who are watching or viewing may not be. Is that when we talk about your Supreme Court, that's the old House of Lords.
It is, yes.
Yeah. Okay.
Yes, exactly. Oh. And then you've got a very. Sorry, Ian, you're going to say?
But Court of Protection, Court of Appeal, and then Supreme Court in your jurisdiction.
Yes, and then if you are the individual as opposed to the state, and you can claim that your rights in some way have been violated under the European Convention on Human Rights, you could then take a case to the European Court of Human Rights. Right. So I have taken one case involving the Mental Capacity Act to the European Court of Human Rights, but they're pretty exceptional, as it were.
Where's the seat of that court, Alex?
That sits in Strasbourg, so in France. Yeah, on the Franco-German border, but it's very after the various world wars, it's ended up in France. So yes, and when Strasbourg hands down, so people quite often call it Strasbourg. When the European Court of Human Rights hands down a judgment, the member state, so in other words, the United Kingdom, is then expected to respond by doing whatever it, if it finds a violation. Yeah. But so no, on the Court of Protection, I think one thing just to frame it with is, and I frame this way because having done quite a lot of comparative things, quite often people from other jurisdictions find this odd or at least noteworthy. We set up a system under the Mental Capacity Act, which came into force in 2007, which is very, very firmly framed on statutory informality. So in other words, most of the time, for most decisions in relation to care and treatment, we'll focus on care and treatment for a second, you don't need to go to any form of court or any form of body to get authority to do it. There's just a piece of legislation which says, if you reasonably believe, and it goes back to that business of reasonable, if you reasonably believe that the person lacks capacity to consent to the act relating to care and treatment, and you reasonably believe it's in their best interest, you can proceed. So normally, if you carried out an act of care and treatment on someone who wasn't consenting, you'd be assaulting them. But what this is saying is you're not assaulting them. So long as you're not acting negligently, you're covered. So there's a very strong statutory steer towards informality, which is, for instance, very different to Scotland, which doesn't have that. And Scots law is much more framed around you need to get formal authority by going to court and getting someone appointed to make the decisions. So we're very firmly informal, but the Court of Protection then sits on top of that to do a range of things. I mean, its core job spec is decide whether or not someone's got capacity to make a decision in the event of a contest. Because we, as with you, are the concept of capacity, and I know we'll come back to this, is decision specific. It's not status specific. I couldn't say you, Ian, lack capacity. That's just a meaningless sentence. It's you, Ian, lack capacity at this point in time to make this decision. So the Court of Protection can make that decision. I mean, obviously it won't do it routinely, but that's where there's a dispute. And then if the person lacks capacity, the Court of Protection can either appoint a deputy to make decisions on the person's behalf, which it does in matters involving money relatively often. And actually, there's a streamlined process. You don't need to go to court. I mean, it's done on the papers. So an application is determined in an office. You don't need to go to court. But on the health and welfare side, the Court of Protection really doesn't like appointing deputies. It much prefers making a one-off decision. So we've now got quite a body of case law from the Court of Protection. Not all of its, by far, not all of its decisions are reported, but there's a big enough body of reported decisions to see all the sorts of things it's got involved in on medical decisions, residence decisions, contact, all sorts of really, up to and including a decision about whether it was in the best interest of a young Muslim man to have his body hair shaved off to comply with the tenets of Islam, which I don't think Parliament thought was going to be happening. That didn't think that was a thing the court would do, but the court could do. And it got into really interesting areas about, for instance, well, what does Islamic law actually require where you've got someone with cognitive impairments? And in fact, it turns out, at least the Islamic experts who reported to the court said, you don't need to shave off his body hair because someone with that level of cognitive impairment is effectively already in a state of grace. So
Right.
and that's why the law's so fascinating. You couldn't answer that question without going off and doing some pretty heavy duty excavation of the kind of cultural, relevant, important cultural norms. So it can do capacity, it can do best interests, and as I say, normally tries to make the decision. The other thing it does, and in a way we don't need to talk about this too much, I don't think, it's a very specific English issue, although it's a much wider issue more broadly, is in relation to deprivation of liberty, because there's been a recognition over the last decade there are an enormous number of people who are deprived of their liberty to receive care and treatment. And I don't just mean people locked up in institutions. I mean anybody who can't consent to arrangements which confine them, which could be in their own home, they could be in a placement which supports them, which isn't a conventional care home. If you can't consent, there needs to be legal authority. And we've got an administrative framework in England and Wales, which the Court of Protection oversees. The only reason for not talking about it, I suspect, too much is, whilst the problem of deprivation of liberty is worldwide, the solution we have in England and Wales and its court's role is particularly parochial, if you see what I mean.
Mm-hmm. No, exactly. The aspect that I think is, and that's right, I think that's quite a specific solution to a universal problem. What I am interested in is maybe just digging a little bit deeper on the assessment of mental capacity. So how that question of how do you assess in various circumstances, and how, and also I suppose how's that related to informed consent. But let's see where the conversation takes us. Take us through your approach to assessing mental capacity. So
I think the first thing to say is, and I'm sure your listeners know this, but certainly in England and Wales, the first thing to say is it's not a medical concept. I mean, capacity, the concept of mental capacity is, well, I always call it a socio-legal medical construct. So in other words, it's an idea that we've got as a society that some people, some of the time, or actually anyone, any of the time, might not be able to make a decision. So we wrote it down in 2005 in the Mental Capacity Act, the idea of what it means to lack capacity to make a decision. I mean, it was building on, famously the story goes, it built on there was a famous decision called Mr. C, all about a patient in a high security hospital who was vigorously resisting having his leg chopped off because he had gangrene. And he came to court for a declaration that he had capacity to say no. Mm. And the judge who heard the case, there was a very good psychiatrist appearing before him, Dr. Eastman. And the judge said, I mean, in a way, going back to just what we were talking about at the beginning of this discussion, the judge was really aware he needed some help to think through, how am I supposed to think about any of this stuff? Mm. So he got Dr. Eastman, he said, Dr. Eastman, can you just help me with what you think the components of capacity are? How am I supposed to engage with the assertion by Mr. C, he's fine? And Dr. Eastman famously came up with, apparently on the back of a postcard, you know, essentially it's down to, can he understand the information? Can he retain it? Can he appreciate it? We changed it slightly language-wise when it came into the Mental Capacity Act, which went through Parliament, so there were debates about, is this, you know, what's the right framework, having had lots of work done by the Law Commission in advance. So it was a kind of thought about process. But ultimately, our test is, can you understand the information? Can you retain the information? Can you use and weigh the information? And if you can do that, can you communicate your decision? Because then there are people, of course, who might well be in something like locked-in syndrome. So they're perfectly cognitively unimpaired. They just can't get in or out. And the law has to go, how do we deal with this person in the black box? So we've got that limb, the so-called functional limb. And then we've got this, people sometimes call it the diagnostic limb, which I don't like, because diagnostic suggests you've got to have a medical diagnosis. Actually, all our law requires is you've got to have an impairment of or disturbance in the functioning of the mind or brain. And one of the reasons I don't like people talking about diagnosis is our Act covers both a high-end debate about, consent to some extraordinary procedure, but also the fact that we had the Danish football player collapsed on the football field during one of the games at the last year in the 2022 UEFA Cup. He collapsed. Someone ran on and performed CPR. At that point, they were doing a very rapid functional assessment of, can this person consent to what I'm doing? No. Can he consent? Is there something wrong with his mind? Yes, he's unconscious. Right, I'll go ahead. And so
as opposed to a formal diagnosis in terms of what is a DSM-5 now, where you have a, which obviously is appropriate in certain cases. I mean, that would be, but it shouldn't be exclusively. It shouldn't be a requirement in all cases. Depends on the circumstances.
Exactly. And I mean, I always use that example in training, because that's quite, if you've waited for a psychiatrist to come along and diagnose, you've been dead, because the person just carried it out and had a reasonable belief, he lived. So it's that, but you're right. I mean, we've got, so in terms of who we consider can carry out an assessment, we've got within our law, well, it can only be X, it can only be Y, it can only be Z. There's certain exceptions for doing this deprivation of liberty business. There's certain people who are required, but just as a general principle. And so it all comes down to, can you coherently explain why you reasonably believe this person doesn't have capacity? And of course, sometimes it can be remarkably difficult to disentangle what's going on. And particularly, I mean, wearing my research hat, I was involved in a big project called Mental Health and Justice, looking at, in part, contested capacity assessments. And so we looked at the kind of more difficult end of the market. And the limb of the kind of test, which is most often problematic, is the using and weighing limb, because it can be relatively easy to probe whether someone can retain information.
Yes.
It can be relatively easy to probe, understand, although you do sometimes discover people have got quite different understandings of what they think understand mean, but there's a sort of broadish idea. But whether someone can use and weigh the information is quite often where the tension creeps in, not least because, I mean, at one level, it's in order to judge whether someone can use and weigh, you're sort of running a test on how do I use and weigh that information. And that becomes the point at which it becomes quite easy to slip inadvertently into, this person's using and weighing information different to me. I'm I'm, as it were, the sane person in the room, to use a really crude term. I'm the reasonable person in the room. This person's using it differently, therefore they don't have capacity. And we've got some very good judgments. I mean, the only advantage, I'm always really careful never to say our court of protection is brilliant, everyone else should follow it. I think that's just wrong, multiple levels, talking to people in other jurisdictions. The only advantage I'd say of our court of protection as a specialist court with a body of judgments which are quite well reported, they're quite good at reporting, especially the higher end stuff. We do have quite a body of case law where you can look and see how judges have thought, and you can pull them up and say that was a rubbish decision, or you can say, actually got that. But there's a really good decision that some of your listeners might find interesting. If you just literally Google sparkly case, court of protection, it will come up with a case about a woman who had previously had a very sparkly lifestyle. She loved money, she's very interested in her own personal appearance, the kind of finer things in life. She's now got breast cancer. She's facing criminal prosecution for assaulting her partner in the kind of context of a collapse of her business. Like, everything is going wrong in her life. And so she decides this is not really how she wants her life to continue. She takes herself off down to the beach, big bottle of pills, big bottle of, I think, Bollinger, champagne. She thinks that's how her life story is going to end. It doesn't. She's now in hospital. She needs renal dialysis. With it, she lives. Without it, she dies. I mean, it's a classic, sad, but classic and not actually entirely unusual. She lives. If she says yes, she has it, she lives. If not, she dies. And the key question is, does she have capacity? And then it came down to, could she use and weigh the fact that if she had it, she lived, which she didn't, she died, she would die. And what she was saying was, I don't care. I just don't care. And the doctors were really troubled about it. And ultimately, the judge found the answer in the evidence of her daughters, her adult daughters, saying, look, we really hate this is a decision our mum wants to make, but this is just who she is. And they actually said, and I thought in a way I've characterized this occasionally as this is a really loving thing to say. Other people have pulled me up and said, well, it might not be. They said, look, this is just the sort of ghastly self-centered thing our mother has always done. This is just who she is. And the judge found that really helpful because it enabled him to say, this is not someone who can't use and weigh. She's just using a weighing according to a completely different value set. Which is
I wouldn't use and weigh in that manner. And I suppose you have to then be very careful as the presiding officer not to, at the point you were making, not to impose your personal view of the world on, because that's not what you're doing.
Exactly.
You're engaging in the exercise of deciding what you would do. You're engaging in the exercise of understanding from her perspective what she wants. Is that right?
Exactly, and you know, it's and it was very fine balanced as to whether or not she had the ability to make that decision. And actually, this is one of those cases. This is one of those cases where the judge pointed out it was important you started with, could you make the decision?
Yes.
Because he said, actually, I think she can. And then he said, had I found she couldn't make the decision, I would have had quite a difficult time because the woman had had no previous diagnosis of any mental ill health until she arrived in hospital and started refusing. And at that point, the doctors said, we think what might be going on is some form of narcissistic personality disorder. And I know you know, and I know your listeners will know, personality disorder is a very contested and very challenging diagnosis. And especially to have it mysteriously appear at the point of treatment refusal, the judge said, I was going to need a lot of help to allow me to say, actually, that was a properly coherent and justifiable reason to find you that capacity. But I didn't have to go there because actually I thought she could understand, retain, use and weigh, and she could communicate her decision. And then she said she continued to say no, and she died. And I know because I've worked with some of the people involved in the case, they still are haunted by it because they had somebody whose life they could have saved. But because she had capacity and she wasn't detained under our mental health legislation, which is a separate zone, and there was no suggestion that she was going to be detained, they just had to respect her no. And that's the kind of price we pay for having a system, as you do, which says at the end of the day, if you've got capacity and you properly tested it, a no must mean a no. Otherwise, you know, kind of, why do we bother with any of this?
Well, then it just becomes the right to refuse treatment. I mean, the inverse of informed consent to treatment.
Exactly.
The right to refuse. So, yeah, all right. So I see how that then became, in a sense, fortunately, became an easier decision to make. And I suppose, and you know, I don't want to speak for the judge, but in a way, maybe alleviated a slight burden because to get to that next stage would have really been difficult and got to the stage where it would have been perhaps afterwards, I don't know, would have thought, I wonder if I did the right thing because it is very evenly balanced. Whereas this route, I think the answer becomes quite a lot more straightforward, put it that way.
Yes, I mean, straightforward, legally, ethically horrible for the people involved.
Absolutely, and that's not to diminish the personal implications and the tragedy of the matter. But then from a legal perspective, the analysis is quite simple. Yeah.
Exactly,
Right.
yeah.
Okay, so that's really interesting. Alex, there was another interesting case that you referred me to involving informed consent and mental capacity and the ability to consent to sexual relations, which has fairly recently been handed down by your Supreme Court. And do you want to just talk me through that matter, please?
Yes, so there's a case called a Local Authority and JB, which was decided in 2021, which actually was the first time our Supreme Court looked at what the Mental Capacity Act meant by capacity. We'd had decisions about other aspects, including what best interest means on the other side of incapacity, but it was the very first time they looked at what capacity meant. And I mean, they did a number of things, including reiterating, you start with, can the person make the decision before going on to ask, well, if they can't, why not? And one of the other things that they said, a couple of other really important things they emphasized, one of them is the fact that our statutory test, and I think, to be honest, any non-statutory test also will inevitably include, the information includes the reasonably foreseeable consequences. So It's not just, do you understand that you're going to have your leg chopped off? It's, do you understand the consequences for you if you don't? And I think those are really kind of important aspects. The Supreme Court also kind of emphasized that in our case, that those consequences would include if the potential for harming someone else, because the critical question in the JB case was it legally relevant that the expert evidence was JB simply can't understand that somebody he's wanting to have sex with needs to be able to consent. His particular cognitive impairments means he just can't understand that. And this is why I come back to it, sort of kind of legal, socio-medical legal construct. He can't do that, but legally it's only relevant if, to his ability to make decisions about sex, if actually being able to understand the other person into consenting is in fact something everybody has to do.
Has to take into account. That's what I got from the judgment was to me that is almost what the judgment turned on. Was this question of understanding that. And it's quite interesting reading the judgment, because it sort of got you reflecting on, well, what is consent? And I thought more broadly, we spoke about drawing broader conclusions, but I thought it was very interesting and got me reflecting on well, what is consent, and the component of me being able to validly consent, particularly within the sexual relationship context, but the other context as well, I suppose, but particularly within that context, is that I must be able to appreciate that the other person, part of my decision as to whether I want to agree is whether they are able to and whether they are in fact agreeing, which I thought was an interesting nuance in the case. It
was, and it's been quite a controversial decision in England and Wales, because a number of people have been upset, and that's demeaning. A number of people have been quite disturbed at the fact that the implications of that are that actually quite a few people with cognitive impairments might actually be held not to have the ability to engage in sexual relations, because they might just not be able to process the fact the other person needs to consent. But I mean, I was in the case, and I remember when for the local authority, so the respondent, the public body, and the lawyer, the barrister on behalf of JB, who did a heroically brilliant effort in trying to turn the biggest, most pro-autonomy argument he could run, which was to try and strip back as much of the information as possible. So just to say, it's legally irrelevant that JB can't understand this. Don't use that to identify him as unable to make decisions about sex. Otherwise, you're going to put in place a horrible regime around him. I mean, a kind of really restrictive regime around him. And the point at which he had to make the submission that part of the relevant information isn't that the other person needs to be able to understand, use and weigh. The two female Supreme Court justices, so the 5 Supreme Court justices, 2 of them are women. The 2 women Supreme Court justices more or less leapt out of their chairs at that point, because what he was effectively having to argue is consent doesn't mean consent. Because in all the fights you've had in all of the places, and still ongoing fights for consent, true sexual consent is actually sexual consent. It is, I am genuinely consenting to this. He was having to try and throw that out of the window to say it's irrelevant in terms of deciding whether or not this person is currently here. It might be relevant for deciding was a criminal act committed after the event, but it's irrelevant for thinking about it now. And the 2 female judges in particular, I mean, all of the judges were going, you what? But the 2 female judges, you could just see that point that you were making in your own mind that was really resonating with them, going, is this man really telling us that we have to ignore something which across all of society? And that's why, and there was a big argument being made that this was, the approach being taken was discriminatory. And the counter argument to that was, well, no, it's not discriminatory. It's everybody needs to be able to understand that in order for sexual consent to be valid. The fact it may mean some people with cognitive impairments can't make that decision is, well, I don't want to use the word tough, but is what it is.
So the point, the discriminatory point, I would imagine would run into the problem that you're not imposing an extra test because of his cognitive impairment. You're holding him to the same standards as everybody's held to, whether you're cognitively impaired or not.
Exactly. The difficulty is, and this may get a bit too involved for here, but the difficulty, that's true. Obviously, in reality, most people, most of the time, don't have their capacity questioned. The people who have their capacity questioned are people who have got intellectual disability or mental health conditions. So the reality is that the kind of eye of Sauron descends on somebody like JB and scrutinizes his ability, whereas you don't have people roaming the streets and nightclubs looking to, well, you know, what is the decision-making capacity of the ordinary person on a night out? And so you're completely right, and the Supreme Court were completely clear, there is no discrimination. It's holding this man to the same test as everybody else. It's the practical reality is most people don't have their capacity questioned most of the time. And it's actually, to be honest, I think a more or less impossible conundrum to get out of.
Yeah, I think so, because as you're talking, the challenge then, and not to extrapolate to different facts, but the challenge then becomes, what about a drunk person?
Yeah. Yeah.
Do you at a particular point, man or woman, or you know, any description, but do you at some point become incapable of properly assessing whether the other person is consenting?
Yeah.
And there maybe there's where there's a slight element of the discrimination argument coming in, because this person is temporarily incapacitated, but we don't scrutinize them. Or do you now? I suppose.
Well, I suppose it also then gets into, I mean, a whole series of views about how we think about alcohol, and then we get into a whole series of views about how we think about, normally we look at all of this through the criminal law after something has happened, and where there is either somebody who is in a position to say, I am a victim, or someone, they're not in a position to say that, and other people are in a position to say there was a sexual encounter which appears to have been non-consensual, and you kind of go back and reconstruct. Just for your listeners, JB's case is different, because what's going on is the decision has been taken in real time. Does JB have capacity to make this decision? And if he doesn't have capacity to make decisions about engaging in sexual relations, the inevitable next step is that he's going to have restrictions placed around him so that he is not in a position where he could commit, well, whether he could commit a criminal offense or not turns on some rather difficult issues about, if you don't have the ability to understand you're doing something wrong, can you commit a criminal offense? But he's not put in a position where he can cause harm.
Practically, what restrictions would those be?
So actually, if you read the judgment, and it's an odd case in a way, because actually the official solicitor, so it's a she at the moment, she's the human who runs the office, who's basically is what's called our litigation friend. So in other words, the person who acts on behalf of the individual who doesn't have capacity to conduct the proceedings in really high end or with last resort, or in cases like this. She actually had agreed on his behalf. He didn't have capacity to make decisions about contact, and he didn't have or capacity to make decisions about his care arrangements. And she'd actually agreed on his behalf, which is interesting to agree something on your client's behalf. But anyway, that's a discussion for a different day. She'd agreed on his behalf that he could have put around him restrictions, which basically mean he is always subject to one-to-one supervision, and he's never allowed to be alone with a woman. And JB has never actually been convicted of a criminal offence. JB is in his late 30s. On the evidence before the court, and I should make it clear on behalf of I acted for the local authority at that stage, I'm not still acting for them, but a lot of work is being done with JB, recorded in the Supreme Court judgment, to try and get him to a position where he can understand. Right. So it's not like he's been given up on. But at least for the time being, JB is under what one might identify as indefinite public protection, or indefinite detention for public protection. The difference is that it's not like being in a prison, because he's in a supported living placement. He's in a place which feels much more like a normal house. But you do start to see, I mean, this is why it's a punch up between two very difficult, I mean, it's a very difficult punch up between two, I think, more or less irreconcilable goods. One is public goods. The one is consent must mean consent, which drives one way, and the other is we want to enable people with cognitive impairments to express themselves sexually, as you know, and not in place improper restrictions. And the two, actually, sex is the area is one of the areas where they get most hard edged, they get up and close in the most sort of uncomfortable fashion.
Yeah. And sometimes those cases can obviously can become quite fact sensitive.
Yes.
And can turn on nuances on the facts. But then going back to the beginning of the discussion, those sort of unintended consequences, those are quite appalling consequences for the individual patient. So for JB,
yes, I mean,
one understands the policy considerations. It's a very difficult case, I think.
It is remarkably difficult, and I was very glad in this case that we did manage to get two interveners. So one was an intervener, the Centre for Women's Justice, who were really able to put very strongly, do you understand how rubbish the criminal justice system is in England and Wales in responding where women, because JB, his sexual interest is in women, how rubbish they are responding to situations where women have been assaulted, and particularly where women may have intellectual impairments, because JB's quite often, the likelihood is that the person JB might have sex with, because of the places he goes, would be somebody with intellectual impairment. So you had that very strong policy position. And then we had an intervention from Respond, which is a charity dealing with people with intellectual disabilities, who were really strongly trying to put the context for, do you understand the consequences if you go there? So this was one of the examples where I think the Supreme Court at least didn't just have the two people arguing, you know, the local authority, public body, and JB. They also did have some contextual stuff. But I mean, I don't know whether I should say this really, but I suppose I don't really mind saying it. I don't think there was ever going to be any good, in inverted commas, outcome from that case. The question is, what is the least bad outcome?
Sometimes it is.
Yeah.
Sometimes it is, Alex. And just the last thought on that, and you know, I'm just sort of thinking as I speak. You wonder whether there's not the potential for a decision being made on his behalf in particular circumstances, which is what happens if there's a woman who genuinely is prepared to consent, and they're now both precluded from having sex.
So one important legal factor just to put in is you're not allowed by the law in England and Wales, statutory law in England and Wales, to consent on someone's behalf to sexual relations. If you don't have
not even a formally appointed curator, what do you say, curator?
No, there are certain decisions in England and Wales which are so personal, no one can ever give consent on the person's behalf. So capacity, marriage, voting. So I think, and a couple of others. So really, really personal things. So unless JB actually has capacity to make decisions about sex, I'm flickering between consent to and decisions to engage in sex. They end up in the same place. Unless he's got that capacity, no one can consent on his behalf. What we do have, though, are from the slightly other angle, because JB was someone who's making it very clear, all I want to do is have a sexual relationship. We do have cases where judges have gone, we think someone does have capacity, but they're extremely vulnerable. So in other words, they're very bad at identifying the risk that other people might pose. And what judges have managed to do there is create a framework which says, okay, this person's got capacity in general to make decisions about sex, but they don't have capacity to make decisions about contact. And so the vetting you're talking about, as it were, can happen through the prism of someone else can make a best interest decision, whether it's in their best interest to have contact with X, where everybody knows the reason they're going to have contact with X is because they're going to have sex. Right. I mean, these are really, at one level, and I've written about this somewhere, actually, so it's in a book chapter, which is forthcoming. You know, you might think this is not an area the law is really very well equipped to be involved in. You know, this is getting right down into stuff where, you know, are we really happy with the law being here? But it's very difficult in England and Wales because we've now firmly asked the question and you can't unask it. And when you've asked it, you start going, oh, help. You
do feel, as you start engaging with it more and more, you start realizing the implications, and there's sort of an almost unraveling that goes on, but you picked at the thread, so I suppose you have to follow it now.
We do, okay. We're slightly numbered with it.
Yeah. All right. Okay, and that is really interesting, and I think it demonstrates the kind of balancing of competing interests and policy considerations, and at the same time, the kind of profound policy implications, but also it's almost it's a juxtaposition between far-reaching policy implications and almost the direction that the law sets itself in and has to make difficult decisions in order to set that direction. And at the same time, this is what comes up with medical law, profoundly personal, intimate decisions that the law is intruding into that domain. And you do get that sense that, well, should the law really be here at all? But of course, I know I understand, take your point about the questions being asked, it can't be unasked, but I think there is another way of looking at it, and that is that in certain circumstances, the law, I think, probably should be involved and does have to make a call on these really intimate aspects of human nature, because, look, those particular circumstances or similar circumstances arise, but it also sets the tone and sets the line, which the law will follow. So you can't really balk away from it because it's a difficult decision.
No, I would agree with you. What I would say, though, is I am not 100% convinced that the courtroom is the right place to thrash out what the law should be doing. I'm a big fan. I mean, I was at our English Law Commission for a while, and I'm a big fan of organised bodies like the Law Commission, or actually legislatures looking at this, because that does then give the opportunity to say, have we really consulted with all the relevant people, and have we really thought it all through? Because it goes back to the discussion we were having earlier, because you always run the risk that, despite everybody's best efforts, you've missed some vitally important point that actually is going to have a massive implication for a whole lot of people who hadn't thought of that. And especially if you get it from our Supreme Court, or your constitutional court, or someone very senior, then it's really difficult to then run around and go, oh gosh, we got that wrong. How are we going to get it back up there to try and kind of? So that's why I think I love appearing in court on those sorts of cases, because I think I like the opportunity to try and frame the law like that. But it's one of the reasons why I spend quite a lot of time not in court, because I'm quite interested in making sure that it's not just seen as the judge's job to do this. Other people need to be thinking to make sure we really are, because you're right, these are unbelievably hard decisions, which then come down to incredibly hard specific decisions in relation to individual people's lives.
And the other problem about undoing it is, because it's an apex court, when does that court ever have the opportunity again to revisit that issue?
Exactly.
Exactly. And what I liked, and as we start heading towards wrapping up the discussion, Alex, what I thought was really interesting was your earlier point about informality. So your statute, as I understood you, the statute setting the parameters and setting the framework, and then not necessarily being the case that you need to approach court for a decision. The law is operating without the need for a decision in a particular matter by a judge. The framework is already in existence. And one of the points that we have a challenge with, and I'm sure in most jurisdictions, including yours, is to approach court, the expense, the delay, the difficulty of getting to a judge, so it was often so prohibitive that these difficult issues simply don't find their way to court at all.
Yeah.
And so there's just an informal way of dealing with it, which is now completely unregulated. And I quite like that aspect. And I thought in many instances that could be an interesting way of approaching a situation which does need guidelines from whatever your judicial structure, whether by way of statute or by way of the courts, more typically, I think, statute in this case. But to marry that to remove it from the need to incur expenses and delays and all the negative aspects of getting through the court process. I thought that was particularly interesting.
Yeah, I mean, I should say there is a counter argument, and I go through this quite often in law reform debates in other jurisdictions. There's a counter argument, which is some people don't like our Section 5 Mental Capacity Act, which is the, as it were, legal informality, because they say that's telling social workers, doctors, nurses, they've got power, as opposed to making them think, I've got to act really carefully here. So there's a kind of, I mean, I think you can look at it one of two ways. I come down on it on thinking, I think it's better to acknowledge that there are an awful lot of these decisions being made, and then at least you've got a really obvious metric against which you can judge, reasonable belief in capacity, reasonable belief in best interest. if someone always has got to be able to justify that, then it seems to me that's a better way, or rather than going, we're not really going to talk about it, or we're going to establish some quite complicated thing which looks really nice in principle, but actually isn't operated because it's too expensive, it's too cumbersome. And we just, human life doesn't wait for the court application to be done in many cases. So in which case you just have something which is done, as you say, with no regulation, with no metric against which to say, was this done right? Which then leaves the medical practitioner going, did I do that right? And then you leave potentially the patient or their family, or the person or their family going, well, how do I say they got it right? I mean, I'm a big fan of people being transparent, and having a kind of as well regulated but discretionary a framework as possible, if you can have the two at the same time.
No, I think you can, and I think that's what you have to strive towards. And what we've seen in our country in the last decade or so is just the crucial importance of the rule of law and the role of the courts and the judiciary, then, which has come under a lot of pressure for political reasons, and has stood up by and large very well, I'm pleased to say. But one of the practical difficulties which we face is how do you ask people to respect the rule of law when access to decisions is prohibitive from a cost perspective mainly, but from a time perspective as well. I don't know what your division, but I mean, we wait for a trial date. Once we've got all our pre-trial procedures ready, we wait about a year for a trial date. And you tell a client who quite urgently needs a result. It's not an urgent application or anything close to that, but it has a profound impact on their lives. They have to wait another year after having jumped through all sorts of hurdles. And you can almost just see the confidence in the legal system draining away. So I think an acknowledgement of that sort of informal operation of the legal system within certain parameters, although ideally you would like every decision possibly to come before a judge, that's arguable. Maybe some people wouldn't like that, but I suppose there'd be an argument to be made that would be a perfect world. But the practical reality is that that's not going to happen. And so how can you impose a structure that works in practice, that can be respected by people affected by those decisions, and that gives the appropriate guidelines after having thought it through? So I think there's a lot to be said for it. I can see the arguments against it, but I think there's a lot to be said for that as far as the operation of the rule of law is concerned. Alex, thank you very much. It's been a real pleasure. It's been a tour de force, and it's lived up to all my expectations. I really appreciate the time. It's been a privilege speaking to you and getting to grips with some critical issues, both within society and within law, and getting a bit of an insight into how the law in England and Wales and more broadly works. So thank you very much for your time, and I really appreciate it.
Brilliant. Well, thank you so much for having me.
Thank you very much, Alex. Good. Cheerio then. Bye-bye.
Bye.